Good evening, everyone. Thank you very much for joining us. My name is Charmaine Clubb, and I'm a family barrister at 42BR.
And I'm Hazel Samuriwo, a family law barrister as well at 42BR.
And tonight we're going to speak about the assessment of ethnic minority families in care proceedings. And in particular, we're going to look at how the courts approach assessment of such families, what assessment should consider, who should assess, and whether there is a scope for change in approach. This is the second webinar in our Family Autumn-Winter series. Earlier this year, the Nuffield Family Justice Observatory published a briefing paper setting out its findings from research into the ethnicity of children in care proceedings. And whilst this talk isn't going to be a deep dive into that research, I think it's nonetheless a useful springboard for our discussions this evening. So I'd just like to start off by highlighting some of the headline findings from that piece of work. So the observatory found that white children account for 78% of children in care proceedings, children from mixed ethnic groups account for 11%, Black children 5%, and Asian children 4%. And what that tells us is that white and mixed children are overrepresented in care proceedings, Black children are slightly underrepresented, and the proportion of Asian children is well below the child population. Interestingly, these findings contrast with the data from the Looked After Children census, which shows that Black and mixed children are overrepresented. The proportion of looked after white children is about right, and Asian children are again underrepresented. At the point of entry into legal proceedings, Black, Asian, and children from other ethnic groups were on average 7 years old, whilst children from white and mixed ethnic groups were on average 5 years old. I think at this juncture, it's not really possible to say what's causing this striking disparity in the data, but certainly I think it does pose questions as to whether the court is intervening too late in some cases and perhaps too early in other cases. Unsurprisingly, London is the most ethnically diverse region, with 60% of children in care proceedings coming from minority ethnic groups in the capital. In terms of deprivation, the research suggests that children of all ethnicities are living in similarly deprived small neighbourhoods, but that Black children tend to live in less affluent local authorities. And in terms of the conclusion of proceedings, the data tells us that white and mixed children are often granted the most interventionist orders, whereas Black and Asian children are often granted the least interventionist orders. And I think this is illustrated most strikingly in the data about placement orders. So we can see on the slide that 16.5% of white children and 15.6% of mixed children are subject to such orders, compared with only 5.8% of Black children and 4.7% of Asian children. I don't know about you, Hazel, but certainly this aspect of the research was quite surprising to me. And I would have thought that Black children, for example, were more likely to be subject to more draconian orders rather than less draconian orders. Do you have any reflections about that?
That's interesting. It may be to do with the two extremes which kind of feature, I suppose, in our presentation today, where the state, they intervene too late in the case of Black and minority ethnic families because of a lack of cultural competency in dealing with those kind of families. And therefore, by the time these families come into care proceedings, they are a little bit too old to be considered for perhaps maybe placement orders. And then I think on the other hand, you also have the problem of the state not being able to understand the various issues that these families are undergoing. So it's something that certainly needs to be kept under review.
Absolutely. I should say there is one exception to this general trend, which is for secure accommodation and deprivation of liberty orders. Proportions of such orders are higher amongst Black and Asian children compared to other ethnic groups. And certainly I think that's an area that needs to be scrutinised in more detail in any future research that's undertaken in this area. Finally, just on the data, I should say that proceedings involving Black, Asian or children from other ethnic groups generally took longer to conclude than for white and mixed children. And just on the next slide here, I've sort of summarised the headline findings of the research. I think although these findings provide an important starting point for research into this area, it's clear that there are gaps in the data. So for instance, for care orders, the data does not distinguish between placement in foster care, placement with family members or a friend, or placement at home with parents. There's no distinction drawn between Black African and Black Caribbean children. I also think the use of the mixed category is potentially problematic, as it may obscure what's really going on the ground. And I think whilst some mixed children might identify themselves as such for the purposes of legal proceedings or a census, that may not be how they identify in their private lives. And indeed, it's probably not how they're perceived by society. I think another crucial gap in the data is the interactions of parents of mixed children with the court system and how that might impact on outcomes. So, for example, a white mother to a mixed child might have a very different experience in the family court and a very different outcome for that family compared to a Black mother. I think what the data also doesn't speak to is a qualitative analysis of how ethnic minority families are being assessed in the midst of care proceedings. And that is precisely what this seminar aims to elucidate. And so on that note, I will hand over to my colleague Hazel, who will speak about how such assessments have been approached by social workers and the courts.
Thank you, Charmaine. So looking at the issue of how Black and minority ethnic families have been assessed by the courts and local authorities, I guess the question really is, how have the issues of race and culture been assessed by the family courts and local authorities? Have these issues been given due consideration, or have they been ignored? And in cases where they have been given consideration, has that been done appropriately or not? Practitioners in this webinar will, of course, be well aware of the welfare principle, which is the key deciding factor when the family courts are assessing as well as making decisions about children. Under Section 1 of the Children Act 1989, the court has a duty to consider the welfare checklist, and that is set out under Section 1.3, which includes matters such as the age of the child, sex, the background, and any characteristics of the child which the court considers to be relevant. Race and culture are not specifically set out, but there can be no doubt that these are considered relevant characteristics. So in considering the question of how these families are assessed, I have looked at a number of reported cases concerning disputes around religious upbringing, also in the context of adoption and physical chastisement. So with the religious upbringing cases, under Section 33(6) of the Children Act 1989, it states that while a care order is enforced with respect to a child, the local authority designated by the order shall not cause the child to be brought up in any religious persuasion other than that in which have been brought up if the order had not been made. So in appropriate circumstances, the parents may apply for a judicial review or seek injunctive relief for breach of statutory duty or under the Human Rights Act. And also, as far as possible, the local authority must ensure that a child is brought up with a full appreciation and understanding of their religious heritage and background. So the first case that I considered, it's on the handout, it's called SM and Others Welfare 2016. It's a 2016 case. Actually, one of our silks was involved in this case. That's Tina Clubb.
Oh, yes.
Yeah, she was with the local authority. So it's a case concerning a Muslim family, very devout, 7 children that were placed in 6 separate placements. Findings were made in relation to physical abuse and sexual abuse as well amongst the siblings, domestic abuse and so forth. And then so this was the welfare hearing. And concerns were raised about how the local authority had failed to provide culturally appropriate placements, but also cater for the children's religious needs, taking into account the fact that the family were devout Muslims. And Mr. Justice Baker stated that the approach to a child's religion and culture requires sensitive handling and analysis, particularly as the child grows older and starts to think independently. There is a danger in our increasingly secular society that those responsible for looking after children in care, both foster carers and social workers, will not truly appreciate the importance of a child's religion and culture. If possible, children should be placed in foster placements that are culturally appropriate. Manifestly, it will not always be possible to achieve a placement that meets these requirements alongside the other welfare needs of the child. In those circumstances, the local authority must devote particular attention to how the child's religious and cultural needs will be met in terms of religious observance, education, and lifestyle, including diet. Now, in this case, after careful analysis of the issues, there was a lot of debate and argument about what was in the children's best interest. The court determined that the children should remain in the placements that they were already in, which, although not culturally appropriate, they were meeting their other needs. I think a special family worker was appointed to assist the local authority in meeting the cultural needs. And then there's another case called RE-A and D, Local Authority Religious Upbringing. Again, a case which concerned children born into a Muslim family, but whose mother had subsequently reverted to her Catholic faith. And the father sought to discharge the care order. The children were placed with the maternal grandparents who were Catholic. And he sought to discharge the care order on the basis that the local authority was obliged to sustain the child's religious persuasion as at the date of the care order, in this case, the Muslim faith. Again, after carefully considering the issues and the arguments in that case, the court decided that, yes, whilst it's the general duty of the local authority to promote a child's religion and to ensure that they remain in the same religion that they were in at the time of the care order, but it shall be the general duty of the local authority as well to protect the child's welfare under Section 17, which actually says that in addition to the other duties imposed on them by this part, they're meant to safeguard and promote the welfare of the children within their area who are in need. And then also Section 22, subsection 3, which states that it shall be the duty of the local authority looking after any child to safeguard and promote its welfare. And in this case, the local authority was entitled to permit the grandmother to teach the child about both the Catholic and the Muslim faiths, demonstrating a proportionate empathy with the different belief systems. Then there was another case as well. I think a lot of people will know about this, the miracle baby case, the Haringey case, 2007. Well, nothing really miraculous. The children, in fact, were trafficked from Kenya And the couple involved, they claimed that these children had been born to them as a result of a miracle. And their religious faith led them to believe that the conception and the birth came about through divine will, and that the placement of the child with others would not be permitted by divinity. And so placement with themselves is what they sought and what they considered was right. The birth parents, of course, were unknown because these children had been trafficked. And one of the issues that the court had to consider is whether religious belief, a factor, of course, that has to be considered under the welfare checklist, whether that should, what consideration should be given in a case like this. And of course, another question that had to be considered was whether adoption has benefits not provided by residence or special guardianship. And Mr. Justice Ryder observed in paragraph 76 of his decision that religious, racial, and cultural factors are integral elements of welfare and may, on the facts of a particular case, provide both positive and negative factors and contexts by and within which decisions have to be made. However, whatever an individual belief system may provide for, and despite the respect that will be given to private and family life and the right to freedom of thought, conscience in religion, and the freedom to manifest religion or belief in worship, teaching, practice, and observation by Articles 8 and 9 of the ECHR, the law does not give any religious belief or birthright a preeminent place in the balance of factors that compromise welfare. And furthermore, the safeguarding of the welfare of vulnerable children and adults ought not to be subordinated by the court to any particular religious belief. And that theme runs through. We don't have time to look at the other cases that were considered in the context of circumcision. Again, these decisions, they demonstrate that whilst religion, culture, and race are important factors to the court, but when it carries out its balancing act in the decision-making process, they are not the determining factor. Well, so far, so good. One may say there may be a bit of a mixed approach. There's a case called A and B against Rotherham Metropolitan Borough Council. It's a 2014 case. One which others may say, did it place too much emphasis on race? It's a decision of Mr. Justice Holman. I must say, this case was the first successfully opposed adoption since the 2002 Adoption Act came into being, and also the first time since the VBS 2013 case, the court has dismissed a contested adoption application, deciding it would be positively better for a child to be placed within their birth family. So this case raised questions as to what approach should be taken in cases where a child is fully settled in a prospective adoptive home. What is the correct application of the nothing else will do test in that context? We're not going to delve so much into the issues of placement orders, adoption, and VBS, but focusing on the ethnicity of this child. It was a mixed race child. And this child was made the subject of an unopposed final care and placement orders due to concerns about the usual risks that we deal with in care proceedings, drugs, alcohol misuse, and so forth. The mother asserted that her partner was the father of the child, which was not disputed by this partner. The fact that both parents were white and the child appeared to be dark-skinned didn't trouble anyone in that case. The most sensible thing really was to carry out a DNA test. When the issue was raised slightly, the mother's partner said this was because his mother was Burmese, and Burmese babies have skin which gets lighter as they get older. Okay. So in that case, the An adoption application was made by the couple A and B in January 2014. And then the real father came forward. He was Black Caribbean. He couldn't look after the child, but he had a sister who could, and she was positively assessed. The judge found that he didn't know anything about this child being in care until quite late into the proceedings. Okay. After hearing all the evidence, one of the concerns, of course, was that this mixed race child had settled very well with the couple A and B for about 13 months. The judge, in that case, Mr. Justice Holman, he refused to make an adoption order, despite the fact that the child had settled well with this couple and for quite a long time. One of the arguments made by the father and the aunt, they emphasized that they and their family were Black African, and the child, of course, was clearly mixed race, and that the applicants were white. This is something which seemed to have really exercised the judge. If you read the judgment, the link is on the handout, which will send out to everyone later. Even though the aunt had been assessed as a good parent to her own son, she wasn't, there were other issues, other concerns in relation to this aunt. The adopters were described as the perfect adopters. Concerns, of course, were raised about the risk of significant harm if the child were to be moved, something that practitioners generally would be concerned about. But Mr. Justice Holman wasn't concerned about that. He was clear that in the short and possibly long term, if he moved from the adopters to the aunt, any harm would be mitigated by his embedded security and attachments with the applicants, which would help him adopt, and could be further mitigated by specialist training and support for the aunt, which she has stated she would gladly accept. So the adoption application was dismissed and the placement order was revoked. Before I talk about the next case, I just wonder, Charmaine, what are your thoughts about this case? The way the judge dealt with the issue of race in the context, obviously, of concerns about moving that child who had formed a bond, an attachment with his carers for 13 months.
I think it's a very harsh decision for the prospective adopters, and certainly I would have concerns about the child being wrenched away from its carers in circumstances where it had been settled for 13 months during a period where a bond was formed. And that time really in a young child's life is really crucial for forming secure attachments. But that said, I can also see, looking at the long-term view, how from the child's perspective, there could be real benefit to being brought up by a blood relative, someone who shares the same heritage and who can help the child understand their identity better. So I think it's a really tricky case, and clearly it's something that weighed on the judge's mind quite significantly.
It did, as we'll see later. So another case, VW, a child adoption grandparents competing claim, almost similar facts, in fact, to this case, albeit the child is of a white background. The trial judge decided similarly in the way that the Rotherham case was decided. The prospective adopters in this case, they appealed. Again, it's a case where family members came very late. It was not their fault. They didn't know anything about the birth of their grandchild. The Court of Appeal overturned the decision made by, it was actually Mr. Justice Bodie. They were very clear that there was neither a right or a presumption in favour of a child being cared for by the natural family, and that this false assertion had created an improper and dangerous reliance on the nothing else will do test. The existence of a viable home with the grandparents should make that option a runner, but should not automatically make it a winner in the absence of a full welfare analysis. Interestingly, the Rotherham case, was mentioned in a skeleton argument by obviously counsel, but not mentioned at all by the Court of Appeal. So one wonders whether, if the prospective adopters in the Rotherham case had appealed, whether that decision of Mr. Justice Holman would have survived the Court of Appeal, and that mixed race child would have been allowed to be wrenched, as you mentioned, from his carers and placed with his black aunt. So what do we make of this? Whichever way Mr. Justice Holman would have gone, the reality is that the public reaction to his judgment was likely to be polarized, with some agreeing and some strongly disagreeing with what he had decided. But in fairness to Mr. Justice Holman, he did say it was one of the most harrowing cases he had heard, and expressed regret at the intense grief his ruling would cause. I was a bit curious to find out what the public actually thought about this. So I did a Google search, and I found this article, The Guardian, the way they titled it, "Perfect White Parents Told by Judge to Give Up Adopted Mixed Race Boy to Aunt that He Has Never Met." And there were other articles similarly titled. Clearly, it was a controversial decision, and some may say that too much emphasis was placed on race at the expense of welfare. So the next case actually I was going to talk about was it's a physical chastisement case. As you all know, physical chastisement is a bit of a hot potato, particularly in Black and minority ethnic families. And there's a decision of Mrs. Justice Hoffley, VA child wardship, fact-finding, domestic violence, 2015 case. So again, there were concerns about domestic abuse as well as physical chastisement allegations made by the child. Mrs. Justice Hoffley accepted that at times different cultural approaches to physical chastisement may be highlighted, and whilst not excusing such behaviour as appropriate, given UK laws and standards, at times a cultural allowance might be given. And this is what she said at paragraph 66 of her decision. "I do not believe there was a punitively harsh treatment of the kind that would merit the term physical abuse. Proper allowance must be made for what is almost certainly a different cultural context. Within many communities newly arrived in this country, children are slapped and hit for misbehaviour in a way which at first excites the interest of child protection professionals." Controversial? So when you read the decision of Mrs. Justice Hoffley, she didn't really believe much of what the father said, actually. She described him as somebody who was troubled. So she described being troubled, by the father's ability to lie when the situation is so it's called for deceit. But she did accept much of what the mother had said. And therefore, the father's assertions that he had simply slapped or tapped A, as opposed to A's allegation that he had been hit with a belt, must of course be placed in that context. So if Mrs. Justice Hoffley was really was troubled, or rather, if she accepted that the child had been hit with a belt by his father on his back and his legs, that it hurt and it felt and it left marks, then some may ask, how can it be said that this doesn't amount to a punitively harsh treatment? And when she said that proper allowance must be made for what is almost certainly a different cultural context, what does she mean by that? Should it be taken that a child from a community where corporal punishment using a belt is acceptable to some, but by no means all in the community, and that society should tolerate that treatment of that particular child in a way we would not if the child were from a different community or cultural heritage. I don't know, social workers who are listening to this, if you come across this decision, whether you'd feel that maybe you may be overly criticized, you may be criticized for overreacting to what may be a cultural norm. And does this judgment carry with it a danger for providing an excuse for hitting and marking a child with a belt when it may be said this should not be acceptable in the first place? Is there a risk that in trying to be culturally sensitive, we are failing to realize that abuse and the effects of it no such sensitivity? And if there's a risk that a cultural deficit, is there a risk that there's a lower threshold of concern and intervention which is not applied to Black and minority ethnic families? So these are all sort of questions that one may ask when they read this judgment. Of course, there is the other extreme that we see when professionals fail to understand the nuances within a particular culture, and they're punitive in their approach, and they take action maybe too quickly, or even when the parents are willing to accept that they've done wrong and they want to make changes, they are not helped to make those changes. And I know Charmaine, you're going to be talking about that in a moment. So these are the cases that I've looked at in the context of how families are assessed by the courts. There isn't time to look at how families are assessed prior to coming to court, but there's some interesting research, particularly when you look at the serious case reviews. An analysis of those cases have found that practitioners need greater confidence and competence in exploring how ethnicity, racism, and culture affect parenting and a child's lived experience. One example, of course, is the Victoria Climbie case, which I'm sure all of us are well aware of. Victoria was a Black child who was murdered at the age of 7 by her 2 Black carers. Many of the professionals who actually came into contact with Victoria were also Black. They made assumptions about culture involving racism and culturally based stereotypes. And so as a consequence of that, there was a failure to recognize that Victoria's needs were the same really as any 7-year-old girl. And there was clear evidence that there was a fear by professionals that if we say something or if we do anything, we're going to be accused of racism, and that therefore hindered child protection professionals from taking the necessary steps. And again, it's a theme which pervades quite a number of serious case reviews concerning families who come from Black and minority ethnic families. Professionals just not being curious enough and not asking the right questions, and quite frankly, demonstrating a lack of cultural competence, not asking difficult questions, which would have helped them to realize the risks that were involved and try and do something about it a lot earlier on. So that's a snapshot really of how families have been assessed within the family court and also by professionals. I'm going to hand over to you now, Charmaine, to look at the next chapter.
So I'm going to speak about what assessments should take into account. Hazel, something you touched on earlier was the absence of explicit reference to race and religion in the welfare checklist. And I think it's curious that sex and age, for example, are listed, but those other protected characteristics are not. I do wonder if it would be perhaps a helpful prompt for them to be included. What do you think?
The difficulty, Charmaine, is that, and I'm sure, like me, you've sat in a number of judgments. I've never come across a judge who's failed to recognise race and religion when actually those issues were relevant. So the reality is that the courts do take these things into account. They do take race and religion into account, even though they're not explicitly mentioned in the welfare checklist. The question is, should they be included? Well, that's a bit of a difficult one because there are many other diversities within diversity. So should the legislation be amended to include all of those other characteristics that exist? One may say that the legislation as it is, insofar as it takes into account all the relevant characteristics, then maybe that's sufficient. I'll be interested to hear what our audience think. Feel free to post in the Q&A.
No, absolutely. I mean, I would agree with you. I think courts do take it into account. The question is whether they're considering the right things when they are looking at the issues of race and religion. I do think it's interesting, though, that in the context of expert assessments, there is express reference to ethnic, cultural and religious factors. So I've put on the slide paragraphs 4.1 and 9.1 of Practice Direction 25B, which stipulates that when an expert is expressing an opinion, they have a duty to take into consideration all of the material facts, including any relevant factors arising from ethnic, cultural, religious, or linguistic contexts at the time the opinion is expressed. And also, the expert must identify the facts, literature, and any other material, including research material, that the expert has relied upon in forming their opinion. So I think it's clear that it's incumbent upon experts to give express consideration to these factors, but also to set out the evidence base to support their conclusions. But in terms of how social workers, experts and the courts should consider the ethnic and cultural context, I'd just like to make a few observations, really. I recognise we are running out of time, so this might have to be a slight précis of what I was going to say. But the first point is, I think it's essential to recognise that the system is geared towards looking at children and families through a white Eurocentric lens. In preparing for this seminar, we spoke to a number of social workers, and one ISW shared with us that in her experience, Black families being treated in really quite a punitive manner by local authorities and CAFCAS, and often children are removed before giving the parents the opportunity to address those concerns, which many of them are prepared to do. She tells us that Nagalro is currently in the process of putting together some publicity for families to really shine a spotlight on this issue. And there are real concerns at the moment that parents are being criminalised when all they need is to be informed and pointed to appropriate training. And certainly that accords with my experience on the ground. I've certainly come across, for example, interim separation of a young Black mother and her baby being sanctioned in circumstances where I would say the threshold concerns were perhaps more trivial than one would usually see. I think looking at the white Eurocentric lens that the courts are undoubtedly operating in, practitioners, social workers, judges are inevitably going to encounter ideas, beliefs and traditions that they are unfamiliar with. And I think that lack of understanding or even fear of difference can have really unfortunate consequences. Hazel, I know you've got an anecdote about a local authority criticising a family for hiding the fact that a so-called blood relative was involved in caring for the child. Could you just expand on that?
Well, Charmaine, I didn't know whether to laugh or to cry when I was reading this. The local authority were concerned that the children called a family member uncle, let's just say Uncle John, they weren't aware that there was a relative who was living in the family home, and therefore they considered that the parents had not been open and honest. There were other issues in that case. And I knew what was going on. And so obviously by the time I took my client's instructions, this family member, Uncle John, was a family friend. And the children called him uncle because in the African culture, we don't call older people by their first name. I mean, my mum, my parents, their friends, I could never call them by their first name. I call them auntie and or uncle. It's very common in our culture. And this local authority in Timbuktu, by the way, they didn't know that. And they were jumping up and down thinking, oh gosh, we were not told about this family member needs to be assessed and so forth. So those kind of misunderstandings can occur when local authorities don't have, or social workers don't have a training or understanding of how things work in the baby community.
Yes, I think that's not a great example. It doesn't reflect very well on that particular local authority, but thank you for sharing that. And I think, as you touched upon earlier with the decision of Mrs. Justice Pawley, the second observation I'd like to make is the fact that there is clearly a tension between reconciling culturally diverse norms around parenting with making correct judgment calls about what constitutes significant harm. I'm sure many of you listening will be familiar with this quote on the slide, judgment from called Riel, where Mr. Justice Headley said, "Society must be willing to tolerate very diverse standards of parenting, including the eccentric, the barely adequate, and the inconsistent. It follows too that children will inevitably have both very different experiences of parenting and very unusual consequences flowing from it. Some children will experience disadvantage and harm, whilst others will flourish in atmospheres of loving security and emotional stability. These are the consequences of our fallible humanity, and it is not the provenance of the state to spare children all the consequences of defective parenting." I think whilst there can and should be tolerance for different standards of parenting, as you said earlier, Hazel, there is a risk that too much latitude means that safeguarding concerns are missed. And that was painfully highlighted in the Victoria Climbie inquiry. So, for example, behaviours such as Victoria standing to attention, being frightened, occasionally bedwetting when our aunt visited her in hospital, those were all seen to be a reflection of African filial piety, effectively, and respect for one's elders. And I think in that case, opportunities to safeguard her were missed due to racist stereotypes and also a fear of being seen as racist. So I think it's really important that where culture-specific practices have been either advanced or assumed to justify allegedly harmful behaviour, that has to be subject to scrutiny. Ultimately, this is about child protection, which really brings me on to my third observation, which is that the task of social workers and the courts is to identify and isolate behaviours which are truly harmful from those which are merely culturally different. And I think that can be achieved through enhancing cultural competence. And to that end, I think it's really essential to undertake training on different sections of the community and on anti-racism. I know, for example, that Children and Families Across Borders offer training on cross-cultural social work practice. So that might be something worth looking into. I also think it's important to gain insight into how childhood is viewed from an ethnic minority perspective. So, for example, the African Charter on the Rights of the Child speaks about the child also having reciprocal responsibilities towards their family, society, and the state. I mean, it talks about the child having a duty to work for the cohesion of the family, to respect their parents and superiors and elders at all times. And I think that notion of childhood is perhaps somewhat at odds with our understanding of childhood in the West. But it's really that kind of nuance that might shed light on why a child is presenting or expected to behave in a certain way. And I think that rather than stereotyping or assuming that certain behaviours are cruel or punitive, it's really important that social workers in the courts are curious and inquisitive and open-minded about understanding the family dynamics and the particular cultural context of that individual child. And I also think any assessment should look at a strengths perspective. So not just the perceived deficits and harms, but also the positives and the protective factors. I know for many ethnic minority families, culture and community can provide a real safety net and a support system and a sense of belonging. And those are all sort of ingredients that help children to thrive. So I think assessments really need to be balanced and recognise those positives as well. Finally, just touching on risk assessments, I know in some communities there is real resistance to admitting fault, even where, for instance, there have been positive findings of physical abuse. And so in those sorts of cases where adverse findings have been made against an ethnic minority parent, it's definitely worth looking into alternative assessment models. So for example, the resolutions model, which is an arrangement whereby a child may nonetheless be returned to their parent despite that parent denying causing an injury to that child. And there are lots of factors that will be weighed into the mix in determining whether that model is appropriate. So, for example, things like, do the parents acknowledge that professionals have legitimate concerns, given the medical evidence and any findings? Are they prepared to work in partnership with professionals in an open and honest way? Are they willing to examine and revise the care they provide for their child? Is there a credible support network surrounding the family? So it's those sorts of things that will be taken into account. Plainly, this model is only going to be appropriate in a small number of cases, and no doubt there'll be many practitioners who might be sceptical of the idea of returning a child to a parent who effectively refutes findings of the family court. But it is certainly something that could be considered as part of any risk assessment into an ethnic minority parent. I'm just going to hand over to Hazel now, who's going to quickly touch upon who should assess. I note that we are running short of time, yes, but we will try to whiz through this as possible.
Yes, so who should assess BAME families? Given what you've just said, obviously a culturally competent professional it is necessary to avoid the difficulties that you've just gone through, anti-oppressive practices with the families who come from BAME backgrounds. So just to say, when we talk about assessments, it's not just the parenting assessment, we're talking about risk assessments, we're talking about psychological assessments, psychiatric and so forth. But just focusing on parenting assessments for a moment, quite often the question is, should it be the local authority social worker or should it be an independent social worker? Well, the starting point, I would say, is the guidance from our president, and this was issued in March last year, 2022. And he said applications for independent social workers or psychological assessments should not be necessary. The culture should be of judges and guardians trusting assessments made by the local authority unless a reason not to do so is established. So the social worker is likely to know the family better than an ISW or a psychologist, and many such assessments add little or nothing to what the social worker can and should be able to tell the courts, and so forth. Okay, so just pausing there for a moment, what do you think about that guidance, Charmaine?
It's a tricky one. I mean, I entirely accept that generally local authority social workers know the family best and will have done the most work on the ground. But that said, turnover in local authorities is pretty high. You know, I've come across families who are on their third or fourth social worker. So I think that somewhat undermines the point that local authorities are always best placed to do assessments. And I can also see this potentially being problematic in cases where there's been a total breakdown of trust between the parents and the social worker. And so I think sometimes it will be more appropriate to have a fresh pair of eyes assessing the parents, particularly where specialist cultural competency is required.
Well, as for me, I have every respect for what the President said, and that would be my starting point. And what I would say to any practitioner listening is, if you've got a case coming up, and of course you're representing a family from the BAME community, you need to find out from the local authority what is their plan of assessment, not on the day of the hearing, obviously, or a day before, at least a week before. Find out details about the social worker who's going to be assessing. Do they have experience of assessing families from the BAME community? Do they have experience of assessing particularly complex cases which are presented by particularly families from immigrant communities and the cultural challenges that are faced by them? Do they have a knowledge of the family and so forth? So you need to find out that information. The local authority may well have a social worker who's known the family quite well, which will be very valuable to the court, but doesn't have the other experience that we just talked about. One way around it is to approach organizations such as Africa. They are very good at helping local authorities with assessments. They can help to prepare a suitable and culturally appropriate parenting assessment plan, and they can work with the local authority in that way. Or you could ask the local authority to find another social worker from a different team who may have the requisite experience, and they can work alongside the allocated social worker. Okay. Something I should have mentioned as well is to look at the post-qualification experience. If you've got a complicated case from a BAME family and you're told that the social worker is just qualified or 1 or 2 years, I'm sorry, that's not going to do the job. So tick, 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 you've got all those things. Sometimes, even when all those things are there and they're present, there's another organisation called Save a Woman as well, who are also very helpful when it comes to assessing BAME families. But all those things may be present, but there may be an issue about how the local authority have worked with the family. There may be genuine issues about independence. There may be evidence, for instance, that the local authority have not been fair in their process. There's been prejudice. And maybe they've already made up their minds before completing the assessment. And I've certainly dealt with such cases before. So if there is evidence of procedural unfairness and all these kind of issues, then you may need to consider an independent social worker. Certainly, that was the case in this VZ, a child independent social work assessment, which concerned a 2-year-old who had suffered non-accidental injuries, leaving them disabled. It was an Asian family. Mum accepted that she caused the injuries. Local authority applied for care and placement orders. Social work assessment of the dad was negative, and they said, we're not going to do parenting assessment as a consequence. And the dad applied for an ISW under Part 25. Now, there are many concerns raised in this case about the local authority's assessment. The procedure was flawed. There was evidence from the looked after child minutes that, so the LAC review minutes, that the local authority had made up its mind before all the sessions with social work had been completed. And so the court allowed the father's application to instruct an independent social worker to undertake a parenting assessment. And this is what the judge said, His Honour Judge Bellamy, sitting as a High Court judge then. He said, and I love this quote and I use it all the time, in a case in which a local authority applies to the court for a care order, the assessment of a parent is of critical importance. That assessment will be a key piece of the evidential jigsaw which informs the local authority's decision making. in particular with respect to the formulation of its care plan. If the assessment is deficient, then it's likely to undermine the reliability of the decision-making process. And it follows from there that any assessment of a parent must be seen to be fair, robust, and thorough. Okay, so just going back to the precedent's guidance, I would be very surprised if the precedent's guidance was to be interpreted to mean that assessment of families, particularly from the BAME community, must be carried out by the local authority, even when there is evidence of bias, unfairness, and or prejudice. What I do think, though, is that the President certainly had in mind a recent Court of Appeal case where the court preferred the assessment of the local authority social worker over that of an ISW with expertise in cultural issues. So the case is called ADA, Children Care and Placement Orders. It's very recent, 2023. Again, one of our colleagues, Zoe McGrath, was actually involved in that case. I think she was representing the child. I did have a bit of a conversation with her about this case. So the independent social worker in that case recommended that the older children should return to the mother. She said that the mother had chastised the children, not to hurt or abuse them, but to discipline them in the same way she was disciplined as a child. And giving an extempore judgment, the trial judge, Her Honour Judge Shanks, sitting at Chelmsford, considered that the ISW assessment was flawed. She considered it was superficial insofar as it took what the mother had said at face value. The judge was concerned about the approach to physical chastisement, which was set out in the report on cultural issues, in which the expert distinguished between its use as a mode of discipline lawful in Jamaica, and its use as a form of abuse. And the judge was also concerned about the short period of time that this expert had been involved with the family. So in all the circumstances, the trial judge preferred the social worker's evidence, which was apparently more thorough, robust, and of course, the social worker had known the family for quite a long time. The decision was appealed, and this is where Zoe, I think, was involved, and it came before Lord Justice Peter Jackson, who gave the leading judgment, and he agreed with the trial judge insofar as they preferred the social worker's evidence. So the appeal actually in relation to the older children was refused, but the appeal in relation to the youngest child was allowed and remitted for a rehearing. So this is a case of an ISW who had the cultural expertise, but actually didn't seem to have done justice. What do you think about that?
Well, I think it's a cautionary tale that specialist culturally competent ISW assessment isn't necessarily always going to be beneficial to your client. I think it's unfortunate in this case that the ISW apparently did not critically analyse what was said and maybe took certain things at face value. But I also think it's a reminder for us as practitioners to the fact that expert assessment is really one piece of the puzzle, one piece of the jigsaw, and the court is the ultimate arbiter of how much weight should be attributed to certain evidence. But yeah, definitely an interesting decision.
Yeah. So I know we're running out of time, but if you could bear with us, the last topic before we conclude, Charmaine, you're going to talk about how lawyers should represent baby families.
Yes, thank you. Just take this very quickly. I think it's important just to remind ourselves of our ethical obligations. So I've picked out C12 and C15, but there are many more that are relevant. And in essence, C12 is all about not discriminating against any other person on the basis of their race, colour, ethnic or national origin. And I think in practice what that means is not simply the absence of discrimination, but adopting and embodying an anti-racist approach. I'm sure many of you will be aware that in November 2020, the BSB published an anti-racist statement, which, amongst other things, set out 4 anti-racist actions for barristers, chambers and practitioners to implement. And I've reproduced those on the slide. But in particular, we can see at bullet point number 3 that we should all be undertaking comprehensive anti-racist training. But I would say it's not simply a checkbox exercise, and it's essential that we all continue our independent learning by reading widely about the subject, by challenging our own thought processes and behaviours, but crucially also by listening to other people's lived experiences and perspectives. Rule C15 is all about representing the best interests of our clients and fearlessly promoting their best interests, and doing so without regard to any consequences to us or any other person, including our instructing solicitors. And I think this duty in the context of representing ethnic minority families can really manifest in a number of ways. So it might be as literal as calling out racist or discriminatory remarks, or reporting such remarks either inside or outside the courtroom. As Hazel has already spoken about, it might mean pushing for a particular type of assessment, a culturally appropriate or independent assessment that might aid your client. It might mean advising your client to instruct different solicitors if they are not being well served by their current representatives and they feel like their needs are not being listened to and understood. Just a couple of other very minor but obvious points. There needs to be ongoing consideration of translating key documents for non-native speaking clients. When it comes to interpreters, I think it's really essential to have a backup plan in case, as so often happens, interpreters don't materialise at court. So having someone that your solicitor can put on the line, for example, just so you can take some instructions, is really essential. And if all else fails, I think just asking the court to adjourn the case so your client isn't left out and they fully understand what is going on at every stage of the process. And I think really the overall message here is, as practitioners, we need to be putting ourselves in our client's shoes as far as possible, and considering how to make the process as accessible and easy to understand as we can, and to really listen to our clients with an open and inquisitive mind to gain a better understanding of the cultural context. Thank you very much for bearing with us. Hazel is just going to wrap everything up with some concluding remarks.
Thank you, Charmaine. So in conclusion, drawing the threads together, it's clear that there are deep inequalities in our care system. The courts, when assessing families, the welfare approach obviously is very key in taking into account what's in the children's best interests. But we've seen how sometimes the interpretation of what's in the children's best interests can lean too much towards protected characteristics, which may not necessarily always work best. We think about social work practice, how it needs to improve to avoid the extremes of either implementing Western-based ideas, but also the other extreme of making the wrong assumptions which place children at risk. And again, as Charmaine mentioned, assessments shouldn't focus only on the negative, but also on the strengths. Effective child protection work requires practitioners to be able to unpick biases and assumptions that may impact on how they perceive and assess the risk to a child. Local authorities, they need to make sure that their staff who work with children, families, they are culturally competent, which obviously involves training, and representation matters, as Charmaine has just touched upon just now. Local authorities and organisations and the judiciary find it beneficial to look at how they can recruit and retain more individuals from the BAME communities. And so there's also a need for more individuals from the BAME community to become judges. And this will assist in building trust and better relationships with the communities going forward. Anti-racist training for judiciary members, and there's the equal treatment benchmark. There wasn't time to talk about this today, but it does highlight that multi-faith and multicultural, multi-ethnic communities, they make special demands on judges and others in the family justice system. And balancing the respect for different approaches to parenting within potentially diverse cultural norms, and at the same time aiming to protect all children from parental maltreatment is a difficult task. It's important to hold the confidence of the parents that they have had a fair hearing. So there's a lot that the Equal Treatment Benchmark has got to say about this subject. So coming to an end, I'm sure you'd be glad to hear this. I know our seminar had the question, when in Rome, do as the Romans do. Was it meant to be rhetorical, or were we meant to answer this? Well, I will give a typical lawyer's answer, which is, you can't really answer that question. I think what one needs to think about really is child safety. And I don't think I can deal with this without quoting what Lord Lamming said in the inquiry regarding Victoria climbing. The basic requirement that children are kept safe is universal and cuts across cultural boundaries. Every child living in this country is entitled to be given the protection of the law, regardless of his or her background. Cultural heritage is important to many people, but it cannot take precedence over standards of childcare embodied in the law. Every organisation concerned with the welfare and protection of children should have mechanisms in place to ensure equal access to services of the same quality, and that each child, irrespective of colour or background, should be treated as an individual requiring appropriate care. There can be no excuse or justification for failing to take adequate steps to protect a vulnerable child, simply because that child's cultural background would make the necessary action somehow inappropriate. This is not an area in which there's much scope for political correctness. Charmaine, in Rome, should we do as Romans do?
I think as we've been going through the seminar, I increasingly think that it's the wrong question to ask. I don't think it's so much about the parents, fundamentally. Of course, they are really important participants in the family justice system, but it's not about them. It's about the children. And I think the question perhaps puts the emphasis in the wrong place. But on that note, thank you very much for joining us tonight for our seminar.
Yes, the next seminar is on the 2nd of November, and that is going to be Eleanor Bethelsden and Samuel Davis, who are going to be talking about the most recent developments in private children law, case law, and the practical relevance to everyday practice. Thank you so much for joining us. We have seen a number of questions that have come through, which we're going to respond to by email, if that's okay, because we've run out of time. Once again, thank you so much for taking part in our webinar.
Thank you. Good evening.